Today I'm going to be talking about the Terry vs. Ohio case in 1968. So first I'm going to go through the basics of what this case changed and established for police officers, and then I'll go through the case with a summary of what findings were found throughout the case, and lastly a brief overview of what the public thoughts were on the case. So the basics. This is a decision made by the United States Supreme Court which held that the Fourth Amendment's prohibition of unreasonable searches and seizures, otherwise known as stop and frisk or pat-downs, is not violated when police officers stops a suspect on the street and frisks him with or without a probable cause to arrest. If the police officer has a reasonable suspicion that the person has committed a crime, is about to commit a crime, or may be armed and dangerous. This is simply for their own protection. After a person is stopped, police are now able to perform a quick surface search of the person's outer clothing for any weapons if they have reasonable suspicion. This reasonable suspicion must be based on specific and articulable facts and not just a hunch. As I mentioned earlier, you may have heard these tactics as stop and frisk, the Terry frisk, or pat downs. The rule was made to not only help officers stay safe, but prevent unreasonable searches from occurring, and only searches that are for the prevention of crime and personal protection to occur. Moving on to the case. On October 31st, 1963, Detective Martin McFadden, age 62, of the Cleveland Police Department, was patrolling downtown when he saw two men, John W. Terry and Richard Chilton, standing on the corner of 1276 Elucid Avenue, acting in a suspicious manner. Detective McFadden, who was well known for his skill in apprehending pickpockets, observed the two men who proceeded alternately back and forth along identical routes, pausing to stare into the same store window. Upon each completion of this route, it was followed by a conference between the two men on the corner. They repeated this alternatively between 5 and 6 times apiece, all in all roughly a dozen trips. After one of the trips, two men were joined by a third, Katz, who left quickly after the conversation. Detective McFadden quickly suspected the two men of casing a job or a stick-up and followed them. He saw them meet once again with Katz, a third man, a couple blocks away from the storefront. Detective McFadden, who was in plain clothes, approached the three and identified himself as a police officer and asked for their names. The men mumbled back to him something, and this is where McFadden then spun Terry around and patted him down, where he found a pistol in his coat. He tried to reach into the pocket but was unable to remove the gun. The officer ordered the three into the store, where he removed Terry's overcoat and took out a revolver, and the order of the three men to face the wall with their hands raised. He then continued to pat down Chilton and Katz, where he seized a revolver from Chilton's overcoat pockets as well. Although he did not put his hands on any undergarments, only the outer overcoats. The three were taken into the police station, and Terry and Chilton were charged with carrying concealed weapons. The defense team of the charged individuals moved to suppress the use of seized weapons as an evidence for grounds that the search was a violation of the Fourth Amendment. Through the trial, the court rejected the prosecution's theory that the guns had been seized during a search incident to a lawful arrest. The court denied the motion to suppress and admitted that the weapons into evidence on the ground that the officer had cause to believe that Terry and Chilton were acting suspiciously and their investigations were warranted, and that the officer, for his own protection, had the right to perform the pat-down. The trial court made the distinction between an investigatory stop and an arrest, and between a frisk and of the outer clothing for weapons and a full-blown search of evidence for the crime. In the end, Terry and Chilton were found guilty in an 8-1 decision, and the Intermediate Appellate Court affirmed the conviction, and the Ohio State Supreme Court dismissed the appeal on the grounds that no substantial constitutional question was involved. So what did the public think? The procedure called stop and frisk was and still is a very controversial one. Police would argue that they require flexibility in dealing with quick evolving and potentially dangerous situations while patrolling the streets, and this is a great handle to them. Yet on the other hand, those suspicious of giving the police broad investigatory power contended that the police should not be able to assert their authority over citizens without some specific justification. Thus, the courts came up with an exclusionary rule, Mapp v. Ohio 367 U.S. 643, making this issue not a question of whether the exclusionary rule was an appropriate deterrent of police misconduct during such encounters.